In this video, we will start with a fundamental threshold question. When or under what circumstances does the buyer have a legal right to reject the seller's tender of goods? That is the question answered by 601 of Article 2, a section that is more commonly known as the perfect tender rule. 601 is called the perfect tender rule because, subject to various exceptions and limitations that we'll address momentarily, it requires the seller to make a perfect tender. There can be no imperfections in the seller's tender of the goods. Stated in the language of the statute, if the goods or the tender of delivery fail in any respect to conform to the contract, the buyer may reject the whole or accept any commercial unit or units and reject the rest. So if the seller's goods or the seller's manner of tender of delivery fail to conform in any respect to the contract, then the buyer has the right to reject the seller's tender of goods. More specifically, the buyer has the right to either reject all of the goods the seller has tendered, or accept all of the goods the seller has tendered, or to pick and choose which of the seller's goods to accept and reject. Stated differently, if the seller's tender is nonconforming, the buyer may accept any commercial units at once and reject the others, and pay the seller only for the units that the buyer has accepted. So the perfect tender rule says that both the seller's goods and the manner of the seller's tender must conform to the contract. Note, conform is a defined term under Article 2, and it's defined under 106 subsection 2 in a manner that you might suspect that goods or conduct, including any part of a performance, are conforming or conform to the contract when they are in accordance with the obligations under the contract. So the conform means that both the goods and the seller's manner of tender must be in accordance with the party's contract. So if either the seller's goods or the manner of the seller's tender fails in any respect to be in accordance with the party's contract, the seller is in breach of its contractual obligations to make a conforming tender of goods, and the buyer may reject the seller's non-conforming tender as a whole. Thus, 601 imposes a seemingly strict obligation on sellers. A seller cannot make a tender that is materially in accordance with the party's contract. That would still be a breach. Instead, what the seller has to tender must be simply in accordance with the contract. Either the seller's tender is perfect or not, and if not, the seller is in breach. So any technical or minor deviation by the seller in what the contract requires, regardless of the reason for that deviation, and regardless of whether that deviation was accidental or knowing on the seller's part, gives the buyer the right to reject all of the seller's goods, cancel the contract, withhold any payment to the seller, and seek damages against the seller for breach. Note, in this way, the perfect tender rule deviates from the common law of contracts. Recall from your study of the common law of contracts. Under the common law, the non-breaching party may suspend its performance and cancel the contract only in the event of a material breach. If the breaching party commits only a minor breach, what is also called substantial performance under the common law, the non-breaching party is still obligated to continue its performance under the contract and is instead limited to seeking damages against the breaching party for its minor breach. In the event of a minor breach, the non-breaching party cannot simply refuse its end of the bargain, refuse to perform its contractual obligations owed to the breaching party. But under the UCC's perfect tender rule, any breach by the seller is treated as a material breach. Any technical or trivial deviation by the seller in what the contract requires enables the buyer to reject the seller's goods, cancel the contract, refuse to pay the seller for the rejected goods, and seek damages against the seller for breach. That all seems pretty harsh from the seller's perspective, and indeed it can be. But it is important that you keep in mind the perfect tender rule is subject to various limitations that ameliorate the severity of this rule. First, the perfect tender rule is only a default rule. The parties in their contract may limit the requirement of a perfect tender, and that agreement may be explicit or implicit. It may be explicit, for example, if the express terms of the parties' agreement limits the buyer's right to reject the seller's tender only in cases of a material defect or deviation from the contract's requirements. But the parties may also implicitly agree to limit the requirement of a perfect tender, implicitly through course of performance, course of dealings, or usage of trade. Recall, these customary terms supplement the express terms of the parties' agreement, supplement by modifying what it means to be a conforming good, such that minor or trivial defects might still be considered conforming. For example, consider a contract pursuant to which a citrus farmer agrees to sell a large quantity of large navel oranges to a wholesaler of produce, and assume that in the produce industry it is widely understood that large navel oranges means navel oranges that weigh between 6 and 9 ounces. But it is also widely understood in the produce industry that there is natural variation in the size of fruit, and at least some minimal number of oranges may fall out of the 6 to 9 ounce range. This kind of trade usage may supplement the parties' agreement to help us interpret what the parties intended under the express terms of their agreement. Given this trade usage, if the farmer delivers navel oranges, the vast majority of which fall into the 6 to 9 ounce range, then the farmer has made a perfect tender of large navel oranges, even though some of the individual oranges fall outside of that range. Under the applicable trade usage, the farmer's tender still conforms to the contract, and therefore the buyer cannot rightfully reject the farmer's tender of goods. The second limitation ameliorating the severity of the perfect tender rule is the implied obligation of good faith. Remember, this obligation is implied into every contract, and good faith may be invoked to prevent a buyer from seizing on some technical minor deviation by the seller as a basis for rejecting an imperfect tender if the buyer is acting in either subjective or objective bad faith. For example, if the buyer was acting dishonestly, seizing on the defect as a mere pretext for rejecting the goods, that could be a breach of the subjective duty of good faith. Or if the buyer's rejection is inconsistent with reasonable commercial standards of fair dealing, that could be a breach of the objective duty of good faith. Finally, the perfect tender rule is inapplicable to installment contracts. What is an installment contract? We have mentioned them before in this course. An installment contract is defined under section 612 subsection 1 of Article 2. An installment contract is a contract where the parties agree that the goods will be tendered in separate lots, that is, multiple installments, shipments, or deliveries spaced out over time. Recall the default under Article 2, specifically under 307 of Article 2, is that all goods are to be delivered in a single lot. But the parties can opt out of that default rule, agree that the goods will be delivered in multiple lots, in which case we have an installment contract. For installment contracts, there is no perfect tender rule. The perfect tender rule is inapplicable. The rationale for this is that where the parties' agreement contemplates an ongoing relationship over multiple transactions or installments, the legal rules governing the parties' relationship should attempt to preserve that relationship where possible. But this does not mean that a buyer in an installment contract can never reject a seller's non-conforming tender. It's just that the standard for rejection is less generous to the buyer. In contrast to the perfect tender rule, under subsection 2 of 612, the buyer may reject any individual installment only if nonconformity of that installment substantially impairs the value of that installment and the nonconformity is not something that can be cured or fixed by the seller. So if the nonconformity is something that can be cured and the seller gives the buyer adequate assurances that the seller will cure, then the buyer cannot reject the installment. Instead, the buyer must accept the installment and pay the seller, although the buyer may still have a claim against the seller for breach due to the nonconformity. Subsection 3 of 612 goes even further by limiting the buyer's right to cancel an installment contract in the event of the seller's breach. It provides that even if the buyer rightfully rejects an individual installment tendered by the seller, the rejection of a single or even multiple installments does not entitle the buyer to cancel the whole contract. Instead, the buyer may only cancel the whole contract if the nonconformity of one or more installments substantially impair. Instead, the buyer may only cancel the whole contract if the nonconformity of one or more installments substantially impairs the value of the entire contract, the value of the contract as a whole. So even if one installment is nonconforming, and that nonconformity substantially impairs the value of that single installment, entitling the buyer to reject that installment under subsection 2 of 612, the buyer cannot cancel the installment contract as a whole unless the nonconformity of that installment and in any previous installments substantially impairs the value of the whole contract, with the sum of all installments contemplated by that contract viewed collectively. Thus, where the parties' contract contemplates multiple installments over a period of time, it can be difficult for a buyer to argue that nonconformity in any one installment substantially impairs the value of the contract as a whole, when that nonconformity is viewed in the context of all of the installments contemplated by the parties' deal. As you probably already noted, both subsection 2 and subsection 3 of 612 use the standard of substantial impairment in lieu of perfect tender. Substantial impairment is akin to the common law's doctrine of material breach. The nonconformity must be so grave that it fundamentally undermines the expectation of the buyer as to what the buyer sought to get out of the deal. Like material breach under the common law, what constitutes substantial impairment of any one installment or of the installment contract as a whole is highly fact-specific. In practice, this means that a buyer must be more cautious in rejecting or canceling an installment contract on the basis of substantial impairment. because it can be difficult to predict ex ante how a court might resolve the question of substantial impairment if the seller challenges the buyer's action in rejecting or canceling. And if the buyer guesses incorrectly, that is, if the buyer believes there was substantial impairment, but a court decides differently ex post, then the buyer's rejection or cancellation would itself be considered a breach. These three limitations, the ability of the parties to agree otherwise, the implied obligation of good faith, and the substantial impairment requirement for installment contracts, go far to limit the severity for sellers of the perfect tender rule. But in addition to these three limitations, there are two others that you should note. First, as we will see later in this module, even where the seller makes an imperfect tender, the seller may have a right to cure. That is, the seller has the right in certain circumstances to fix its breach. And second, there's a practical limitation on the ability of buyers to exploit the perfect tender rule. That is, that a buyer who rejects goods for a technical or very minor deviation will earn a reputation in the marketplace, a reputation that makes other sellers unwilling to do business with that buyer. So, as a pragmatic matter, buyers have a reputational incentive to not misuse or abuse the perfect tender rule. One final note before we conclude our look at the perfect tender rule. As we said at the beginning of this video, the perfect tender rule defines when the buyer has a legal right to reject the seller's tender of goods. But even when the buyer does not have the legal right to reject the seller's tender and to refuse to make payment for the goods, nothing can prevent the buyer from doing so. But when the buyer rejects a tender that the buyer does not have a legal right to reject, then the buyer breaches its own contractual obligations to the seller to accept and pay for the seller's conforming tender of goods. Stated more simply, the buyer's wrongful rejection puts the buyer in breach, thus entitling the seller to a remedy against the buyer. So with that final note, we can conclude our look at the perfect tender rule. In the next video, we will assume that the buyer has the legal right to reject the seller's tender of goods, and we'll ask, what does the buyer need to do to effectively exercise that right?